We are.
One second here. Let me. All right, the meeting is yours.
Thank you. Good morning, everyone. Lynn, can you go ahead and take the roll for us?
Sure. Good morning, everyone. If I don't call your name, it means I've marked you present. But a lot of coming in right here at the last minute. So please just let me know if you're here. Wayne Ritchie. Catherine Barnett. Brandon Bass. Bo Burke. Donald Caparella. Michael Carter. Wayne Ritchie. Jim Hivner. Mark Folks.
I'm here.
Morning. Sarah Key. Representative Lambert. Alex Little.
I'm here.
Great. Good morning.
Good morning.
Tim Mickle. Is that you on your cell phone?
Yes, ma'am, I'm here. I'll be
Awesome.
joining by video in a moment. Yes, thank you.
Good morning.
And hi, it's Catherine Barnett. You're past me in the alphabet, but I just got on. Sorry about that.
Wonderful. Thank you. Judge McGee. I'm counting, Gino. I'm not sure that we have a quorum.
Okay.
Hey, Lynn, it's Elizabeth. I think a few people have joined who you passed up already. So it looks like Bo Burke is on and Jim Hivner. That
Great.
helps you.
Thank you. I think we have a quorum now.
We also have Judge Greenholtz and Captain O'Neill, who are voting members. So I didn't hear their names called. So
I marked them present. Justice
Okay.
Dridewater. I saw them. Thank you, sir. I think we have a quorum now, Gino.
All right. Thank you, Lynn.
Thank
Well,
you.
let's go ahead. And before we dive into the agenda this morning, Justice Tarwater, are there any thoughts or comments you'd like to lead us off with?
well, perhaps I jumped the gun on myself just then, but I'd like to introduce two new members of the commission. Judge Tom Greenholtz from Chattanooga, a member of the Court of Criminal Appeals, will be our liaison from the Court of Criminal Appeals, replacing Judge McMullen, who served, I think, for 7 or 8 years on the commission in that role. And so we are very thankful for her service, and we're thankful to have Judge Greenholtz join us, who is the rules aficionado of a major order. So there you go. So welcome, Tom.
Justice Tarwater, thank you so much. I can't tell you what a privilege it is to be a part of this commission in particular with all of its members. And I look forward to adding just a very little bit to it and learning a lot from all of you. Thank you so much for allowing me to be of service. And I know Judge McMullen's shoes are very large to fill, so I won't even try that, but just hopefully be a productive member.
Thank you, sir. And Captain David O'Neill from Brentwood, also a member of our of the bar. And we're delighted to have you join the Rules Commission, Captain O'Neill.
Thank you so much. I'm honored to be able to learn from and work with such an esteemed group.
And I feel compelled to just say good morning and welcome back to my old and dear friend Andre Blumstein, now a member of the private sector. If we need to borrow some money, we know who to call now, Andre. So good to see you again.
It's good to be here again. And I'm taking a little break before I start back to work. And so I'm relying on home technology, not office technology. And I hope it all works okay. Got my fingers crossed, but it's good to be with you all.
Andre, taking a break?
Yep.
The apocalypse is near.
I have a few closets that need cleaning out.
All right, Mr. Chairman, take it away.
Thank you, Justice Tarwater. And I'm going to advance item number 3 on our agenda because we have a special guest with us this morning, Judge Russell Parks, who has brought a particular issue to the attention of the Rules Commission. And we're going to go ahead and begin by letting Judge Parks explain the nature of his concern and what he proposes. Judge Parks, the floor is yours.
Thank you, Gino. I've had the pleasure of practicing for 28, almost 29 years before I took the bench, and I've litigated with and against and alongside some of you and litigated in front of others, and now have had many of you litigate in front of me. Rule 24 of the Rules of Criminal Procedure, whether it be the single entry or entity or the separate entity jury selection process, specifically provides that when a juror is not selected to be a member of the deliberating jury, that juror shall be discharged when the jury retires to consider its verdict. There's a companion or sister provision in Rule 47 of the Rules of Civil Procedure, and it provides almost identical language. And it says a juror who is not selected to be a member of the final jury shall be discharged when the jury retires to consider its verdict. Mandatory language. That is problematic for any trial judge. And I'll just give you a practical example. I was in an 8-day jury trial. The jury received the case at about 6 p.m. and began to deliberate. There was a problem that arose over the course of the evening after I allowed them to go home at approximately 9 that night. They came back the next day and deliberated virtually all, or I guess they did deliberate all day. If I adhere to the mandates of Rule 24 or Rule 47, I shall discharge the alternates. Now, if someone becomes ill or there is some jury misconduct or juror misconduct, I have to try and replace that particular juror, or I disqualify or release that juror. I'm without alternates. I release them, and I can't plug them in to then ask them to begin their deliberations anew. And I am proposing or asking the commission to consider a change in the mandatory language under Rule 24 and Rule 47 to allow that to be discretionary. In other words, simply change the shall to may. It sounds simple, it sounds easy to give us that discretion. And what it does is it would allow the trial judge who faces a problem such as that to have a number of options. One, they can still declare a mistrial if they so choose and not plug in the alternate. They can plug in the alternate, arguably, and instruct the jury to begin their deliberations completely anew, including the deliberation and or election of a foreperson. But I don't want to put this commission out on a branch with no support. there's some history about this particular rule. And in fact, in 1991, the Supreme Court, Justice DeWoda, writing a dissent joined by Justice O'Brien, dissented about this very rule. And I'll get to the language, but in just a moment. But in the case of State versus Bobo, the court, in analyzing the plugging in of a alternate after the jury had begun their deliberations, said the following. And it was after the Court of Criminal Appeals had already analyzed the issue. It said, as pointed out by the Court of Criminal Appeals, the procedure used in that case, State versus Bobo, clearly violated Rule 24E1. They had plugged in an alternate after the deliberations had commenced. That rule provides only for the replacement of a juror who becomes disqualified prior to deliberations, and states that any alternate not replacing a juror shall be discharged when the jury retires to consider the verdict. At that point, the discharged alternate is no longer a member of the jury, since the function of an alternate juror ceases when the case has been submitted. Now, in that case, it's a little factually, it's factually different from what I've posed. They let the alternates go. A juror was disqualified. They then summoned the juror who was at work to come back in, voidired the jury, plugged them in, and let it proceed. There was additional language in that case that states that the alternate juror who replaced Ms. Coleman, in that case the initial juror, took part in all of the deliberations. Those deliberations were to begin anew once the alternate was reseated, but without an explicit instruction to that effect from the trial judge. We cannot assume that the reconstituted jury panel started from the beginning. Justice DeWoda, a great analysis, said this in the dissent. It's a 3-2 decision. The court has asked the Advisory Commission on Criminal Rules, appointed pursuant to 16.3.601, to study and recommend changes to Rule 24E of the Rules of Criminal Procedure. Trial judges need guidance on how to proceed when this problem arises. I feel the per se approach taken by the court today curtails further study by the Advisory Commission. So it's not as if this commission hasn't been asked previously by someone on a much higher level than I to look at this. And he went through a number of other states who had, including, I think, California, who had a rule that vested discretion in the trial court to replace. There was also an analysis in the case State versus Hester in 2010, citing Bobo, that was decided by our Supreme Court. And in a unanimous opinion by Justice Koch, it was a death penalty case. Someone became ill after the guilt phase, but during the sentencing phase, and the trial judge replaced the juror. And they said that was okay because it was a second phase of the jury, and the jury there was not a mandate that they be released or discharged. So it's not without recognized issues, but and from a practical standpoint, it's probably not going to come up very often. Hopefully never. But at this point, if we have a jury who, and I've discharged the alternates, and I have not retained the alternates and segregated them, I'm left with either trying to really force that juror to stay on if they're ill, have them come back in a few days when the illness passes. But if they're disqualified for another reason, I really have very little choice at this point other than the lawyers agreeing to proceed with a jury of 11 rather than 12. And so this would simply vest the trial judge with discretion to do a number of things. One, replace with an alternate. I would also suggest, if this commission adopts this proposal, that the committee comment also include a recommendation to the trial judge that when the jury begins to retire for purposes of deliberation, that the alternates be segregated, instructed not to deliberate, not be allowed to deliberate with the jury of 12, and only if a juror of the 12 becomes disqualified, ill, or for any other reason, that they then plug them back in, and the trial judge instruct the jury that they have to begin their deliberations completely anew, including the selection of a foreperson. Interestingly enough, there's a number of federal cases on point dealing with criminal cases where a judge or a bailiff allowed alternates to be in the room during the initial jury deliberations. When the judge learned, he brought them all back out, segregated the alternate, told them they had to begin anew, and they said that was constitutional. So that is the nature of my request. I just think it vests the trial judge with discretion. And from a practical standpoint, some judges do it now anyway. I do it. I ask them to be segregated. I segregate them, instruct the bailiff to segregate them. I've never had to plug anyone back in. And I ask the lawyers in open court on the record to waive the provisions of Rule 47 or Rule 24 to the extent they can do it. And at least I would have waiver in the record if I had to plug someone back in. So that's the nature of my request and suggestion. And if this commission amended the rule, I would suggest to the Tennessee Pattern Jury Instruction Committee to fashion a jury instruction for trial judges to use in the event they had to plug someone back in as an alternate into the jury selection, into the initial jury or into the jury. So I'm happy to answer any questions.
All right. Thank you, Judge Parks. Does anyone have any questions for Judge Parks?
Gino, I do.
Yeah, Alan, please.
I guess you hinted on the reason for the rule, and that's to maintain the integrity of the deliberations of the original panel. So you would be asking us to give you authority not to release them and to provide a procedure for them to be segregated. I think that's the reason for the rule, because that would potentially taint the deliberations. Am I correct in that?
That's correct. And I think that the advisory commission comment that would instruct the trial judges that if they plugged in an alternate because after deliberations commenced, they would have to instruct the jury, the reconstituted jury, if you will, to begin their deliberations anew. There are a number of cases, Tennessee cases, that indicate that the trial judge who had done that, they were reversed because they had not given a sufficient instructing them to begin their deliberations anew. So you're right, Alan.
Judge Parks, this is Alex Little. Have you looked at the federal rule on this?
I have, because many of these cases cite the federal rule. Now, I haven't looked at this in preparation for today. Unfortunately, I'm in Wayne County today about to hold court, so I don't have my full file of this in front of me.
I just put it into the chat. If you can see the chat on your Zoom, I think that it is an odd way that we do it now. That's a shall and doesn't permit this under the rule. I do think the federal rule, though, does deal with the two issues that arise. It actually includes in the rule the obligation that the alternates must be segregated during deliberations or until they're discharged. And it does include in the rule itself a statement that after deliberations have begun, the court must instruct the jury to begin its deliberations anew. So I think I would prefer that approach. If we're going to change the shall to may, then we sort of give the obligations that have been addressed by the cases both in state and federal court in the rule itself. And I think it works. I will say one concern I have, I've been on juries where we have in federal court, we have had to replace jurors. I think, judges who get used to doing it do it pretty regularly. You know, a lot of times if we have 3 alternates, the parties will agree to discharge 2 at the beginning, maybe hold on just to 1, that sort of thing. I do think particularly in complex criminal cases that have gone for weeks and weeks and maybe months, where you get deliberations that go on for more than a week, maybe going into a second week on a really hard murder case or death penalty case, there is a real difficulty for jurors to adhere to the last sentence, to the obligation to begin things anew. And so I think there is some concern about putting in, I would want or hope to figure out if we could put in some language to make it clear, something even that says in the interest of justice, the court shall, so long as it's in the interest of justice or something. So that there is at least a recognition that we can point out in the comments that that particular part is hard if we're in that sort of case. It's not going to come up often. I don't think it'll come up often in civil cases, but I can see it a really contentious, very long deliberation criminal case, some constitutional concerns about the sort of idea that they can just start anew. But I like the federal rule a lot, and I would be in favor of us sort of adopting that sort of language for those folks who want it. As I said, I've put it in the chat there. But I think it's a good way of dealing with all the problems that you've addressed, which I can't imagine, losing jurors mid deliberations and then saying, "Oh, nothing we can do about it." So I do think this is a good change.
Gino tried a case in front of me for 5 days. Not too long ago, the jury announced at 6 or 7 p.m. they wanted to continue to work into the night and return the verdict at 12:04 a.m. on a Saturday morning. I cannot imagine having to start that case that we tried for 8 to 9 hours every day. Starting that one anew, they wanted to get it finished because one said they were flying to Europe on Monday, another had work obligations, and they were willing. I was going to keep them on Saturday. I would have no problem with putting all of those things in the rule itself. I think that's a great idea.
When it got to be about 11:30 in the evening, Judge Parks, I was interested in trying to select alternate plaintiff's counsel in that case, but never quite made the motion.
Put that in the rule.
Yeah, but thank you for bringing this to us because the proposed rule change affects both rules of civil procedure and criminal procedure. I'm going to exercise a bit of privilege of the chair and actually have an ad hoc committee address this. I'm going to appoint myself as a member of the ad hoc committee to look at this and report back to the full advisory commission in June. Alex Little, would you be available to serve on that committee as well?
I would.
Catherine Barnett, could you serve on that committee as well?
Yes, I'd be happy to.
And Judge Greenholz, could we ask you to serve as our advisory member on that ad hoc committee to address these proposed changes?
Absolutely. I would love to. Thank you.
All right. Well, I will be in touch with each of you. Elizabeth Ryan, did you have a comment?
I do have a question. I wanted for
Sure.
you all to think about as you have this conversation. Alex, your comment about some type of interest of justice, perhaps exception or provision, I'm a little, it gives me a little bit of heartburn in some ways, just thinking about that and like, how is that determination going to be made? Is that by the trial judge? Is that because the jury foreman comes forward and says, this would be too difficult for us to begin our deliberations anew? How is that going to be evaluated, measured? I feel like if that's going to be something that's thrown in there, that's going to have to be something to be considered.
For
so
sure.
I just throw that out there.
And I don't know what the right answer to that is, sort of offhand, impromptu, but I think the idea would be, I think if the language was such that it looked permissible, such that if there were that would bar any sort of challenge down the road. I think that the concern is if I don't want the language of the rule to read as if it must be done this way. And if the court found some reason to say, I don't think this is appropriate to start anew, that the court could entertain a motion for mistrial. And I think that the idea was not to sort of prevent that from happening. I'm not saying it was the opposite. I think it's sort of you don't want to foreclose the option to argue that in this circumstance, it is not appropriate.
Okay, got it.
Understood. All right, Judge Parks, thank you again for bringing this issue to us today. And you're welcome to stay for the rest of the meeting, but I understand you've got a jury there in Wayne County. So,
well, not a jury, but I do have a number of other cases. And Judge Greenholz, I'll be happy to talk to you. There is a Court of Criminal Appeals opinion that cites the Bobo case. It's written by Judge Ogle, and they deal with whether it's structural error or not. And so that's, I want to be fair and say that, and Alex, I know that you may be aware that case is out there, and I'll provide a site to you if you need.
Great.
That's right, Judge Parks. Thank you.
Okay, all right. Thank you very
Okay.
much.
Thank you,
Gino.
Judge Parks. That'll take us back, members, to item number 2 on our agenda. Lynn has put together a detailed set of minutes from our last meeting in December. Do I have a motion for approval?
Move the adoption.
Do I have a second?
Second.
Any discussion on the minutes? Hearing no discussion, all in favor, please indicate by saying aye.
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 Any opposed, nay? All right, Lynn, we've got a unanimous vote in favor of approval of the minutes. That'll take us, members, to item number 4 on our agenda, which is the first of the 3 items we'll be voting on as an advisory commission today. The first issue deals with proposed revision to Rule 23.06. And that was something that's been brought to us by the Rules of Civil Procedure Subcommittee. And Doug, are you prepared to go ahead and address that?
Scott is prepared to go ahead and address this.
Okay, Scott. Good morning, Scott. The floor is yours.
Good morning. Thank you, Mr. Chairman. Okay, so this deals with a proposed amendment to Rule 23.06 regarding the disposition of residual funds in class action litigation. The rule as written gives the trial judge complete discretion as to how to disperse those residual funds, and then it permissively allows the court to allocate those to pro bono legal needs of Tennesseans, which has led to some perceived the complete discretion has led to some perceived abuses in the past, potentially worthy of an amendment. The Rules of Civil Procedure Subcommittee has looked at this issue, and we believe that an amendment of some sort is in order. There should be some discussion because there are a number of potentially suitable alternatives. What we provided for you at page 11 of your meeting packet is an opening bid, if you will. And I must say that Brandon Bass did the legwork on all this. He did really good work. He's got a hearing this morning. He may join us in the midst of this discussion. He may miss this discussion, but if he joins, I'm sure he'll have some more to say. But in his stead, I'll say that the proposed rule that we're putting before you removes complete discretion from the trial judge and gives instead limited choices. Number one, the judge can rule that the residual funds should go to the interests of the class members, some cause that is in the interest of the class members of the litigation, or that furthers the objectives of the litigation on the one hand, or those funds can be sent to the administrative offices of the courts for access to justice purposes. That's the way we crafted it for openers. There are other ways to do this. We did a survey of other jurisdictions. Some jurisdictions take the position that residual funds should be used only for the interests of the class members or the objectives of the litigation, and that unless and until that is deemed unfeasible, it cannot be routed to access to justice. So a primacy for the interests of the members of the litigation, and then only if that's not feasible, then it could go to access to justice. Other jurisdictions mandate that a certain percentage of the funds to be set by the court go to help the indigent, and the remainder would go to the interests of the class members or the objectives of the litigation. And then a third kind of moving part is here we've designated that the funds go, if they're going for indigent purposes, they go to the AOC. That it doesn't have to be specified in the rule that the AOC would be the sole recipient of those sorts of funds. You could direct that to any nonprofit that assists with access to justice. So the questions really are, how do we want to balance the interest of the class members and the objectives of the litigation versus funds for access to justice. And if we want to make a provision for access to justice funds, how do we want to advise trial judges to think about that and route that? Do we want to give them wide open discretion, or do we want to direct them to the AOC? I don't think anybody thinks it's a good idea for trial judges to have complete discretion as to where residual funds go. I think we do feel strongly that they need to be limited, but the question is limited to what and in what manner. So with that, I'd open it up to discussion, because we are, like we say, not wedded to this proposal. It's just for starters.
All right. Any questions for Scott? Well, Scott, I like the revisions that came out of the subcommittee. And if the subcommittee is comfortable with the revisions as drafted, if you'd like to make a motion, we can go ahead and get it up for a vote today.
Doug, is that appropriate, do you think?
I think it is. I think there was unanimity among those of us on the subcommittee.
Okay, well, then I would make that motion, Mr. Chairman.
Can I ask one question before we move on that point?
Sure.
Just to the AOC, I assume that they have already a capacity to do, like, if they get funds for this, they've already got a place for it to go and a program that it would go into. We're not kind of going to burden them in any fashion, I assume.
The answer to that.
I'm sorry, Scott, I didn't mean to break in, but since Michelle's here with us, I thought maybe we could have her address it on behalf of the AOC.
Hey, everybody. It should be fine. I mean, our Access to Justice program does, receive funds for this type of purpose. So I don't really see a problem with this at this point.
And so I guess my question is that specific enough that sort of, if a judge does this, it will very easily be tied to the right place, and they won't have to, that'll be a fairly efficient process.
It should be. I mean, it should be fine. I did not run this by our fiscal director about it. I mean, I can if we want to wait on it, but I'm not sure that needs to at this point.
Yeah, and to be clear, I don't have the objections to the idea. I just want to make sure administratively that we don't have some person stuck at the AOC with having to administer something new. But it sounds like, Michelle, I appreciate your info and knowledge on that's not going to be a problem.
Yeah, no problem. I mean, if everyone, I know that I don't think anyone wants to wait on this, but I can triple check with our office if we want to wait on it. But I think we should be able to administer this.
All right, Scott, was there anything you wanted to add to that?
No, I'm ready to move if and when appropriate.
Okay, we have a motion. Do we have a second?
I would like, I was going to say, I would like to second the motion. What I might suggest, if I might, as a slight amendment, is that we second it and go ahead and approve it, subject to Michelle being able to confirm that it's not going to be an issue. And as long as it's not, then, the proposal moves forward.
Sure, Tim, and because we proceed in this commission under Robert's Rules of Order, there is a procedure for us to reconsider our actions. If Michelle were to come back and tell us that for some reason or another, the procedural posture of this just won't work, we can always do that. But given her confirmation that this looks like it will work, thank you for your second. So we've got a proper motion and a proper second. Do we have any further discussion on the proposal before we take a vote?
Gino, I would just add that it's probably not final until we approve the minutes at the next meeting anyway. And that's the time when you can reconsider. So I think we have an opportunity to adjust it if we need to. I think we can go forward and approve it today.
Also a great point, Alan. Thank you. Any other discussion regarding the proposed revision to Rule 23.06 of the Rules of Civil Procedure? Okay, Lynn, if we could, let's go ahead and take a roll call vote on this one.
Sure, happy to do that. Catherine Barnett?
Yes. Great job.
I don't think Brandon Bassett's here just yet. Let's just see if he's chimed in now, joined us. General Blumstein?
Yes.
Jim Bowman,
Yes.
Bo Burke,
Yes.
Michael Carter,
Yes.
Wayne Ritchie. I don't think he's here. Scott Sims,
Yes.
Alan Wade,
Yes.
Chancellor Cole, Jim Hibbner.
I believe I'm a non-voting member.
Okay.
Me
Jim
too.
Hibbner.
I'm a non-voting member as well.
Okay. Mark Falk,
Yes.
Doug Hallahan,
Yes.
Aaron Hall, Captain O'Neill,
Yes.
Sarah Key,
Yes.
Julian Kelly,
Yes.
Alex Little,
Yes.
Tim Mickle,
Yes.
Representative Lambert. Okay. Unanimous in favor of this particular amendment.
Great. Thank you, Lynn. You can also record me as a yes.
Yeah.
Okay. Wonderful. Thank you all very much. Let's move, if we could, then to item number 5, also coming to us from the Rules of Civil Procedure Subcommittee regarding a proposed new comment to Rule 26.02 subsection 4. Doug, is it you or Scott that'll take this one?
Yeah, this one is me.
Okay.
So
The floor is yours, Doug.
Thank you, Mr. Chairman. Just by way of very brief refresher on this, we have discussed over the past 2 meetings sort of a general proposal having to do with the expert disclosure rules under Rule 26.024. After pretty fulsome discussion of the pros and cons of amending the rule to make more explicit what the disclosure obligations are as to non-retained experts, so-called actor experts or viewer experts, the commission was kind of the view, well, there were sort of 2 views, but both of them weighed against a full-scale amendment to the rule. One was that trying to amend the rule to address this particular issue would open up a kind of a Pandora's box of considerations that the commission members didn't feel like were ought to be addressed or ought to be made. And then there was a feeling among some members, I believe, that, you know, if it ain't broke, don't fix it kind of thing. So where we came out on this was just with the idea to add an advisory commission comment that addresses the fact that Rule 26.024 does not, unlike the federal rule, unlike some other state rules of civil procedure, but by no means all, but just acknowledge expressly that the rule does not address actor or viewer experts, and that under, more than one applicable Tennessee Supreme Court cases, the one we cited is kind of the most recent, most kind of complete opinion on this, the White versus Vanderbilt University case cited there at the end, that an advisory commission comment clarifying this and noting that because actor or viewer expert disclosure is not provided for expressly in the rule, simply means that they are treated as, their facts or opinions are treated as any other ordinary witness under the rule. So we tried to write a simple, plain, straightforward advisory commission comment that just clarified this so that there's sort of no, potential confusion going forward about how it works. And so the subcommittee on the civil rules recommends for adoption this advisory commission comment that's set out on page 12 of the packet.
Okay. And before we dive into discussion, I'm going to treat that recommendation as a motion. Doug, do we have a second to it?
Second.
Okay. All right. Anyone, any questions or comments regarding the proposed comment that Doug has just outlined for us? Well, let me go first, Doug. I think it's exceptional. I love what y'all have done in the subcommittee because this does, I think, provide some great clarity both to the bench and the bar as to how these somewhat hybrid witnesses are to be treated. And we do it in a way that's faithful to the Tennessee common law, the case law that we've got, as well as the existing rule. And it does exactly what I think it should under Alessio versus Crook and White versus Vanderbilt University. It specifies that an actor reviewer witness is not somebody who's contemplated to be disclosed under 26.02, but that, of course, they are a fact witness that needs to be disclosed under the other provisions of Rule 26. So we've got a motion, we've got a second. Do we have any further discussion before we take a vote on this one?
I have a question, if I may.
Please.
About where it says that are not expressly covered by the rule. That somehow implies or could imply that they're implicitly covered in some way. And so my question is whether that word expressly is really necessary or advisable. Maybe just leave it out.
Doug, any thoughts about that?
My gut reaction is I'm pausing because I'm rereading the whole sentence. I don't know that I feel strongly about that either way. I mean, obviously, if Scott or anybody
I
else
don't feel strongly either. I just
I don't know that Andre, I don't know that I necessarily think it implies something that's not correct, but on the other hand, I'm not wedded to the use of the word expressly there either. So whatever the commission as a whole believes there, I don't know that it's necessary, but I don't feel strongly about omitting it, since I guess it is true that the rule does not expressly address actor experts.
All right. Well, not to be overly formalistic, Doug, but will you accept as an amendment of Andre's proposed revision?
Yes, I will.
Okay. All right. The motion as amended now is as reflected on page 12 of your materials, less the word expressly, which is being stricken at the request of one of the best brief writers in the history of our state, former Solicitor General Andre Blumstein. All right. Thank you, Andre. Any other comments or questions or discussion? All right. Lynn, if we could, let's go ahead and take a roll call vote on this as well.
Catherine Barnett,
Yes.
General Blumstein,
Yes.
Jim Bowman,
Yes.
Bo Burke,
Yes.
Michael Carter,
Yes.
Scott Sims,
Yes.
Alan Wade,
Yes.
Mark Folks,
Yes.
Doug,
Yes.
Captain O'Neill,
Yes.
Sarah Key,
Yes.
Dulin Kelly,
Yes.
Alex Little,
Yes.
Tim Mickle,
Sorry, having trouble unmuting. Yes, please.
Gino.
Yes.
So unanimous in favor of this amendment as.
Great. Thank you. Thank you, Doug, and your subcommittee for all your hard work on this one.
Thank you.
That obviously will take us, Tim, to you. Item number 6 on the agenda, proposed amendment to Tennessee Rule of Appellate Procedure 22. Tim, the floor is yours.
Thank you. I'm gonna sort of tee it up and then perhaps pass it off to Alan if he will indulge me. This is an issue that we brought to the floor at our last meeting. It started out as what seemed like a fairly simple assignment, but with all things, there were a few complexities that revealed themselves along the way. Really, the initial goal of the committee was to amend Rule 22 of the Rules of Appellate Procedure that governs the filing of motions on appeal to allow for the use of declarations under penalty of perjury, which seemed like, a pretty straightforward thing. But as we got to talking about the rule and talking about the actual application and process that goes on within the clerk's office, there was some concern about making it look like an affidavit or declaration under oath had to be filed in support of each and every motion that got filed, and the unnecessary paperwork that would entail. So we, in trying to restructure the rule, we tried to recraft it a bit to make clear that it was not necessary in every instance that an affidavit or declaration be filed, but that led us to saying, well, but there may be some instances where they should be. So in either case, we've addressed all of those and brought that before the committee. At our last meeting, Alan very astutely addressed some concerns about making sure that there was, I suppose, comedy between what we said in Rule 22 and what is said in the Rules of Civil Procedure governing the necessary content of the unsworn declaration. So we tabled that discussion for a moment so that Alan and I could potentially in our subcommittee get together and discuss this. We were a little slow in doing so, but found out to our horror that we were perhaps holding up the Supreme Court by not being as expeditious as we should. So Alan has gone ahead and made some proposed amendments to our prior amendments. And Alan, I'm going to just now step aside and let you discuss those. I will note that it looked like to me that as we're discussing this, I'll go ahead and note that there might be a typo in the comment in the next to last sentence where it should say include only. Right now it says include on. So I would suggest that we fix that. But beyond that, I'm going to be quiet.
Okay. Alan.
Thanks for volunteering me. When I looked at the proposed rule, and my experience has been that this is something that practitioners get wrong all the time. I've had a number of cases where the court has had to issue show cause orders to correct a motion that wasn't in proper form and was not sworn to. It just seemed to me like we do with briefs, we can identify what we want the contents of the motion to entail. And then I also added the specific language from Rule 72 and imported that into this document so there won't be any question about what form of statement under penalty of perjury has to be submitted. I'm really not necessarily wedded to my proposal. I think the rule as drafted by the subcommittee addresses everything. I just thought some more specificity would be helpful to the bar and to the clerk's office in terms of evaluating and to the court evaluating when motions are appropriate or not. And I had a question about the Rule 46, Supreme Court Rule 46 amendment. I think the committee said that was outside their purview, but I'd like Elizabeth to tell us if that is actually necessary. If we approve the changes to 22, it seems to address everything that would be needed to be done in an appellate motion or document. And I don't know what Supreme Court rule would add, and maybe I'm missing something, but maybe you could comment on that.
Elizabeth, could you address that, please?
Certainly. The court has just tabled really any discussion about an amendment to Rule 22 pending or waiting to see what the commission would do with Rule 46, or I'm sorry, I'm backwards, Rule 20,
You're backwards.
Rule 46 and back with 22. So you may be correct. It may be unnecessary, and the court will take that up and in light of whatever amendment is made by the Rules Commission or recommended by the Rules Commission to Rule 22. So,
sure.
All right, thank you.
And Tim, for my part, I love what you and your subcommittee have done with the revision on page 13 of our materials. And then if we simply make that one change on page 14 from using the word on to using only. Would you like to make a motion to adopt this on behalf of the subcommittee?
I would. Thank you, Mr.
All right,
Chair.
do we have a second?
I'll second.
Great, thank you, Alan. All right, further discussion or comments on the proposed revision to Rule 22 of the appellate rules? Hearing none. Lynn, let's go ahead and take a vote.
We're busy today. Catherine Bennett.
Barnett, yes.
Sorry.
No worries.
General Blumstein.
Yes.
Tim Bowman.
Yes.
Bo Burke.
Yes.
Michael Carter.
Yes.
Scott Sims.
Yes.
Alan Way.
Yes.
Mark Falk.
Yes.
Doug Hallahan.
Yes.
Captain O'Neill.
Yes.
Sarah Key.
Yes.
Julian Kelly.
Yes.
Alex Little.
Yes.
Tim Mickle.
Yes.
Last but not least, Gino Bolso.
Yes. Great.
Unanimous.
Okay, wonderful. Thank you again, Tim, for you and your committee's work and Alan's work as well on that revision. I think it's excellent. And we certainly do not want to slow the Supreme Court down. That's rule number one for the work of the Advisory Commission.
That information kept me awake last night.
Well, I just hope you don't have any cases currently pending before the Supreme Court, Tim, but that's another issue. All right, members, that'll take us to item number 7, a discussion item not to be voted on today. This also comes to us from the Rules of Civil Procedure Subcommittee. Doug, is there someone from your subcommittee that will address this? Scott, to take the floor, it's yours.
Yeah. Yes, unfortunately, you guys are hearing way too much from me today. This is not a new issue. This is a proposed amendment to Rule of Civil Procedure 9A. And the thought was whether we should note the deadline to appeal a final order terminating parental rights on the order itself. And we discussed this at the last meeting. There are pros and cons. Among the pros are that parental rights are fundamental. Often you'll have pro se litigants in this context, I understand, and often lives are in crisis when these proceedings are being held, and that these people may need a little extra help in understanding when the appeal deadline is so that something doesn't happen that they would otherwise have wanted to challenge. The cons are that, this is not a unique situation amongst, legal proceedings, and we don't do this in other contexts. Number two, I understand from the judges and clerks that this would be a burden on them. And number three, the impact of this legend or notation not being made on an order, what downstream consequences will that have? So after the last meeting, our subcommittee was asked to take these comments back and deliberate some more. We did that, and at the end of the day, it was the feeling of our subcommittee that the cons outweighed the pros. And so the recommendation would be from our subcommittee that we not make any such amendment to Rule 9A.
Thank you, Scott. Questions, comments from any of the commission members? All right. Well, thank you again, Scott, for your work and the subcommittee's work. Sometimes the best changes are the ones we don't make.
Right.
That just sometimes happens.
Thank you.
But yeah, thank you for looking at that, and thank you for running it to ground for us. We've got 2 deferred items, members. Item number 8 regarding a proposed change to Rule 52.01 of the Rules of Civil Procedure. Tim, is there anything that you want to bring to the commission's attention with regard to that rule today?
Not at the moment, other than we need to get our subcommittee. It looks like it is a question of whether 5201 or the rules of appellate procedure need to be amended. So we'll take a look at that. I wasn't aware of this particular question, but we will. I guess I need to get together probably with Scott and and perhaps put our heads together on whether one or both of our subcommittees need to be dealing with this particular issue.
All right, and it's something that, if it is something that we need to deal with, obviously we can handle it at our meeting in June. And then also I note that deferred item number 9 has to do with Rule 42 of the appellate rules regarding a delay in the issuance of the mandate. Is there any feedback you want to give us or input you want to seek from the commission today about that issue?
Well, the feedback I will give on that, and I may turn to Elizabeth. At last blush, the clerk's office that was considering, the Supreme Court clerk's office was considering what direction we wanted to take on that. As I understood it, the entire issue opened a can of worms, and there were more issues in discussion there. There were other things more pressing on their agenda, and they were still in the process of considering how they wanted to address that. Is that a fair statement, Elizabeth, or have things moved on past that from your end?
That is a fair statement, and I will tell you in discussions this week, it's an even bigger can of worms than I could have ever imagined. So the can of worms is still open with us, and we have nothing.
But that all being said, Mr. Chair, we will work to get our subcommittee together in short order and have some updates on both of these items at our next meeting.
Great. Which is a good.
Gino.
Sure.
I'm sorry, but before we leave the Rule 52 issue and the related issue with the Rules of Appellate Procedure, as our subcommittee chairs determine what to do with that, I just wanted to remind you all that Judge Childress originally brought this issue up. Might be someone that you want to check with. And if we discuss this at a meeting, we might want to invite Judge Childress to appear as Judge Parks did today. There are differing viewpoints on if or how a change should be made between the trial judges on one hand and the Court of Appeals on the other. So it might be that Judge Clement or Judge Sweeney would also have a point of view that might need to be expressed on that. So as you all do your work, keep them in mind, and then you might want to determine if any or all or none of those should be invited to the next meeting whenever a proposal is made or we have a business item to consider.
We will try. I mean, from my perspective, I would love to get, that insight at the subcommittee level as well, if that's appropriate. So I would be all for reaching out and trying to, and again, I think Scott and I can talk a little bit about how best to do that, whether we do it jointly or independently, but I do appreciate that suggestion and would like to incorporate it into the way we get this done.
Yeah, I think that would be wise, and you won't have any problem getting your calls returned on this, I don't think so.
Sounds like something else that needs to be taken care of quickly.
Great. Thank you, Justice Tarwater. The next item for discussion is our next meeting then. Ordinarily, we'd be meeting on the second Friday in June, which would be the 14th, but because that is judicial conference, we're going to be moving that meeting to the following Friday, June 21. And you'll be receiving formal notice of that, everyone. But if you could, note your calendars today that our June meeting will be on June 21, the third Friday rather than the second. And also, we are going to return to our pre-pandemic format, where we're going to have in-person gatherings for the advisory commission, one in each grand division. And in the middle district, of course, it'll be here at the AOC. And then obviously we'll have video conference and telephone connectivity as well. But we're going to go ahead and get back to our normal means of meeting in June for the meeting on the 21st, and hope that both fosters a sense of collegiality and letting us all get together and see each other in person from time to time. And then at some point, we may want to schedule an in-person meeting of the entire commission somewhere along the lines, just to, once again, make the group a bit more cohesive and connect everyone a little more so than we have in the past remotely. Justice Tarwater, any other comments you've got before we entertain a motion to adjourn?
None from me. Thank you all so much for this great work.
Okay. Any comments from anyone for the good of the order before we adjourn? Okay. Then we will consider ourselves adjourned, everyone, and y'all have a great weekend, and we'll be in touch and look forward to seeing you all again in June.
Thank you.
Thank you.
Bye.